Section 11, Americans with Disabilities Act Compliance Kit, today's Fair Housing Rules and Regulations, 2026 Standard. Introduction, from understanding ADA to implementing it in your business. In the last section, we broke down the Americans with Disabilities Act and how it applies to real estate, focusing on accessibility, public accommodations, and the difference between ADA and fair housing requirements. Now we take the next step. Understanding the ADA is one thing. Implementing it in your real estate business is another. This section is your practical compliance guide, your ADA toolkit for 2026. It answers the real questions agents, brokers, and brokerages face when trying to apply ADA rules in offices, transactions, and daily operations. Because in today's environment, compliance is not just about avoiding violations. It's about creating systems that prevent problems before they happen. Title I, Employment and the Real Estate Brokerage. Let's start inside your office. Under the ADA, a qualified individual with a disability is someone who can perform the essential functions of a job with or without reasonable accommodation. Now here's where it gets interesting in real estate. Most agents are classified as independent contractors, but that classification is not always absolute. The relationship between brokers and agents may be examined to determine whether agents are truly independent or function more like employees. 2026 Risk Insight. If your brokerage operates like an employer, controls schedules, duties, or behavior, you may fall under ADA employment requirements. Also important, if your brokerage has 15 or more employees, ADA Title I applies, and that includes combined totals across multiple office locations. Real-world example A, brokerage with 3 offices and 5 staff members at each location meets the 15-employee threshold and must comply. Title III, Public Accommodations and your office. Now, let's move from employment to your physical location. Under ADA Title III, any place of public accommodation must be accessible. This includes real estate offices, leasing offices, training facilities, any location where clients meet you. Even if you run your business out of your home, if clients visit, that portion of your home must comply with ADA accessibility standards. 2026 Application. If a client cannot physically access your office, you may already be in violation. ADA versus Fair Housing Act. Overlapping coverage. One of the most important compliance concepts is this. A property can be subject to both ADA and fair housing laws at the same time. For example, a residential building, Fair Housing Act. The leasing office inside that building, ADA. These are separate analyses, and both must be followed. The readily achievable standard, real decision making. Now let's talk about one of the most practical parts of ADA compliance. Barrier removal is required when it is readily achievable, meaning easy to accomplish, not overly expensive, reasonable based on the size and resources of the business. This is not a one-size-fits-all rule. It is determined case by case based on cost, business resources, operational impact, safety considerations, real-world example, 2026. A large brokerage may be expected to install permanent accessibility features. A small independent office may rely on temporary solutions, like portable ramps, if permanent ones are not feasible. Accessibility in existing versus new buildings. The ADA sets different expectations depending on the situation. 4. New construction, full compliance required. Renovations, must incorporate accessibility. Existing buildings, must remove barriers if readily achievable. However, ADA does not require extreme modifications, such as installing an elevator, if it would create excessive cost or structural burden. Historic properties, a special consideration. In Arizona and across the country, many properties have historical significance. The ADA recognizes this and does not require modifications that would destroy the historical integrity of a structure, unless accessibility can be achieved without compromising that value, model homes, open houses, and real estate practice. Here's a question agents often get wrong. Are model homes and open houses required to comply with ADA? Generally no, because they are not considered public accommodations. However, if part of the home is used as a sales office, that portion must comply with ADA requirements 2026 best practice. Even when not required, providing some level of accessibility is strongly encouraged and reflects professionalism. Shared responsibility, landlord versus tenant. Another key compliance issue involves responsibility. If a property is leased, the landlord and tenant both share responsibility for ADA compliance. Responsibilities may be allocated in a lease, but liability remains shared. Real-world example: a retail tenant fails to make their space accessible. Even if the lease says it's their responsibility, the landlord can still be held liable. Communication and accommodation. Beyond physical access. ADA compliance is not just about ramps and doorways. It also includes communication. This includes providing interpreters when necessary, offering auxiliary aids, ensuring effective communication. The key standard is effective access and communication must be achieved. And the best practice: ask the individual what they need. Real-world example, 2026. A deaf client requests an interpreter for a meeting. You must provide a qualified interpreter, not just someone who knows a little sign language. Good faith effort, your legal protection. One of the most important protections for your business is demonstrating good faith compliance. If you develop an ADA compliance plan, take steps toward accessibility, show effort to accommodate. This can reduce penalties, even if a violation is found 2026. Takeaway: doing nothing is the biggest risk. Trying and documenting your efforts is your protection. Bringing it all together, your ADA compliance strategy. At this point, your role as a real estate professional includes understanding ADA requirements, recognizing when they apply, advising clients appropriately, implementing compliance practices in your own business. This is your ADA compliance kit. Know the law, apply the standards, ask questions, document everything, act in good faith. Because in 2026, accessibility is not optional, it is expected. Online discussion. Question 1. When does ADA apply to a real estate office? Answer: when the office is open to the public or clients visit, making it a place of public accommodation. Question 2. What does readily achievable mean in ADA compliance? Answer: it refers to accessibility changes that can be made easily and without significant cost or difficulty. Question 3. Why is good faith effort important in ADA compliance? Answer: because it can reduce penalties and demonstrate an attempt to comply with the law.